I inherited a log cabin built before the Civil War. A woman in pearls said it didn't match the vibe. She fined me $9,000 for existing. She tried to condemn my home in 6 weeks. I lost sleep. I lost patience. Then I found a folder my grandmother hid for 60 years. The judge read one page and started laughing. My name's Wade Callahan. Log cabin my family has owned since before North Carolina paved its first road. It sits on a ridge above what's now called Sable Ridge Lake, a name some developer invented back in 1998. My wife Sarah and I kept chickens, split our own firewood, and mostly kept to ourselves. We weren't rich, and we didn't need to be. The cabin had good bones, a tin roof that sang in the rain, and a view of the water my great-great-grandfather picked out himself. Life stayed quiet until the lake got discovered. Vacation homes sprouted around us, and a homeowners association arrived to organize what had never needed organizing. The Sable Ridge Lake Estates HOA formed in 2003. Drawn up by a development company that bought most of the shoreline from old timber families. My cabin's 5 acres sat right in the middle of their master plan, an inconvenient wrinkle nobody could smooth out, because my family had recorded a land grant on that ridge in 1847. For years the HOA mostly left us alone. New owners moved in, built their beige stucco lake houses, and treated our cabin like quaint scenery in their vacation photos. I didn't mind. Who passed our fence line every morning, never guessing one of them would eventually try to take my home. Deborah Winslow moved into the estates in 2019, buying the biggest lot on the North Shore with money from a divorce settlement nobody quite understood the details of. She ran for HOA president her second year there and won unopposed, mostly because nobody else wanted the headache of managing landscaping disputes and mailbox color complaints. Deb, as she insisted on being called, treated the HOA presidency like a governorship. She wore a lanyard with a laminated badge to community events. She kept a 3-ring binder titled Covenants, Conditions and Restrictions, that she carried everywhere, thick with sticky notes flagging violations only she seemed able to see. The first time I met her, she was standing at the end of our gravel driveway with a clipboard, squinting at our cabin like it had personally offended her. "This is a distressed structure," she said, not bothering to introduce herself. I told her it predated her subdivision by a century and a half. She wrote something down anyway. Sarah laughed it off that night. "She'll get bored," she said, "once she realizes we're not in her association." I wanted to believe that. But something about the way Deb had looked at our cabin, jaw tight, eyes calculating, told me this wasn't a woman who let go of things easily, especially things she'd decided didn't belong. Over the following months, Deb's newsletters grew more pointed. Community standards bulletins mentioned certain unsightly structures near the North Access Road, without naming us directly, though everyone on the ridge knew exactly who she meant. Neighbors started giving us sympathetic looks at the mailbox cluster, the kind reserved for people about to be in trouble. I checked our paperwork out of habit more than worry. The original 1847 grant, signed by a state land commissioner, sat somewhere in my grandmother's cedar chest, along with deeds updated in 1921 and 1968. I hadn't looked at any of it in years. Property law wasn't something I'd ever needed to think hard about. My grandmother Ruth had died 3 years earlier, and I'd inherited the cabin outright, along with a locked steamer trunk she'd always called the family insurance policy and never fully explained. She used to say, half joking, half not, "Someday somebody's going to try and take this land. Wait. Don't let them talk you out of what's yours." At the time I'd nodded along, assuming she meant developers wanting to buy us out, which had happened twice already. I never imagined the threat would come wearing floral prints and driving a Lexus SUV with a Sable Ridge board member parking permit hanging from the rearview mirror, weaponizing bylaws instead of blueprints. Deb's obsession with our cabin wasn't really about aesthetics, though she framed it that way in every letter. It was about control. Her binder listed every property in the estates by lot number, every violation logged with photographic evidence, every homeowner ranked by compliance. Ours was the only lot she couldn't touch, and that ate at her. By late spring, she'd started attending county planning meetings, asking pointed questions about grandfather clauses and non-conforming structures, building a case before she'd even told us she was building one. I only found out because Pete Alvarez, a local surveyor who'd done work for my family before, mentioned Deb had been asking around about our boundary lines. She wanted to know if your grant was ever properly re-recorded after the county redrew its maps in the 70s. Pete told me over coffee. I told her it was, far as I knew. She didn't seem to like that answer. I thanked him, not yet understanding how much that conversation would matter later. Sarah started keeping a folder of her own, copying every HOA notice we received into a manila envelope labeled Deb. Felt paranoid at the time. Looking back, it was the smartest thing either of us did in those early months, though neither of us had any real sense yet of how far this was going to go. By July, the passive aggression had a name and a due date. A certified letter arrived citing Section 4.2 of the Sable Ridge Covenants, demanding we bring our exterior structure into compliance within 30 days or face escalating fines. I read it twice, then called the number listed. Deb answered on the first ring, like she'd been waiting. "Mrs. Our property isn't part of the HOA," I said, keeping my voice level. "Every property touching Sable Ridge Lake falls under our jurisdiction," she replied, like she was reciting scripture. "Not one recorded before your association existed," I said. She paused, then said something that told me exactly what kind of fight this was going to be. "We'll see what the board decides," she said, and hung up before I could respond. That night I dug our full deed history out of the file cabinet, laying it across the kitchen table. Sarah read over my shoulder. "This says 1847, she said.
"How does a woman with a laminated—"
I didn't have an answer. Town, and paid a courthouse clerk $20 to pull our recorded documents, just to confirm what I already believed. Everything matched. Under an 1847 land patent, decades before the county even existed in its current form, let alone any HOA. Armed with copies, I mailed Deb a polite but firm letter explaining our property's legal status, attaching the recorded grant number for her records. I thought that would end it. Instead, 3 days later, a fine notice arrived for $200, citing failure to respond to compliance request within statutory window. She'd ignored everything I sent. At the next HOA meeting, held in the clubhouse, Deb had personally lobbied to build with special assessment funds. I stood up during public comment to clarify our property status for the whole room. Several neighbors nodded along. Deb smiled thinly from the head table and said, "We'll let the board's attorney weigh in on that." Her attorney, turned out, was her nephew's law school roommate, a man named Marcus Feld who did HOA compliance work on the side. He sent a letter a week later insisting our historic exemption required formal board approval through an appeals process Deb herself controlled. It was a closed loop, designed so she'd never have to lose. I hired my own lawyer that week, a sharp, no-nonsense woman named Nadia Chun who'd handled property disputes in 3 counties. She read our documents in about 4 minutes and looked up at me like I'd wasted her time asking. "This isn't complicated," she said. "Your land was never subject to their covenants. Not for one single day." "Then why is she still pushing?" I asked. Nadia shrugged. "The law says they care about winning." She wrote Deb a formal cease and desist regarding the fines, citing the recorded grant and asking for written confirmation the matter was closed. Deb's response, forwarded through Marcus, was one sentence: "We disagree with your assessment." The fines kept coming, $200 a week. Stacking in a drawer, I started calling the delusion file. Nadia told me not to pay a cent, since paying could be read as acknowledging jurisdiction. Deb apparently hadn't considered that possibility, because when the fines went unpaid, she escalated to threatening a lien on a property she had no legal claim to. Word spread through the estates faster than any newsletter could manage. Some neighbors quietly told us they thought Deb had lost the plot. Others, the ones who owed her favors or feared her clipboard, kept their distance, worried association with us might land them on her list too. I started to understand how much power she actually held. One evening, our neighbor Ellen Rourke, an elderly widow who'd lived on the lake since the original development, knocked on our door with a casserole and a warning. "She did something similar to the Hendersons 2 years ago," Ellen said quietly. "Made their lives miserable over a fence. They sold and moved just to get away from her." That story stuck with me. It meant this wasn't Deb's first campaign, and it likely wouldn't be her last if we caved. Sarah and I talked late into the night, deciding we weren't going anywhere. "This is your family's land," Sarah said. 170+ years. "We are not letting her write us out of it." Deb, meanwhile, escalated her rhetoric at board meetings, calling our cabin a blight on community property values in the official minutes, a phrase that would later prove costly for her, though none of us knew that yet. She began circulating a petition among homeowners, framing our refusal to comply as arrogance rather than a simple matter of law. Chuck Renner, the HOA's vice president and Deb's most loyal ally, started patrolling the road near our driveway on his golf cart, snapping photos he claimed documented ongoing violations. I caught him once photographing our woodpile like it was contraband. "Just doing my job," he said, not quite meeting my eyes as he drove off. By September, Deb had convinced the board to authorize further legal action against our property, though she was vague about what that meant even to her own members. Marcus Feld sent us a letter threatening to pursue an injunction requiring us to cease occupancy pending compliance review. Language so absurd Nadia actually laughed reading it aloud. "An injunction to stop you from living in a house that predates their entire subdivision," Nadia said, shaking her head. She either doesn't understand property law, or she thinks nobody will check her math. I asked which Nadia believed. "Honestly,
People like her assume confidence is the same.
That confidence, I'd soon learn, wasn't baseless arrogance alone. Deb had connections at the county assessor's office, a former sorority sister who owed her a favor from years back. What Deb was quietly attempting, we wouldn't discover until much later, was to get our parcel reclassified in a way that would erase our historic protections on paper. October brought the first real escalation. Deb filed a formal complaint with county code enforcement, alleging our cabin violated multiple safety codes, from improper wiring to an unpermitted addition that didn't exist. An inspector showed up unannounced, apologetic but obligated to check. He walked our property for 20 minutes and found absolutely nothing to cite. Whoever filed this clearly hasn't been inside, the inspector said, glancing at his clipboard. Your wiring's newer than half the houses on this lake. I thanked him, relieved, but also unsettled. Deb hadn't just complained. She'd fabricated specifics, details detailed enough to trigger an official visit, which meant she was willing to lie under her own name. Sarah started documenting everything on her phone after that. Dates, times, exact wording of every interaction. If she's willing to make things up to the county, Sarah said, we need proof of our own, not just memory. Felt excessive at the time. Within weeks, it would become the backbone of everything we eventually took to court. Deb's next move came through the community Facebook group. A post claiming certain residents were flouting community standards and endangering property values for everyone. She didn't name us, but attached a photo of our cabin anyway, tagging it with a laughing crying emoji that dozens of neighbors reacted to before anyone thought to defend us. I stayed off the group entirely, but Sarah screenshotted every comment. Most were harmless piling on from people who didn't know better. A few, though, came from names we recognized. Homeowners who'd been personally strong-armed by Deb before and were now, seemed, either genuinely on her side or too afraid to say otherwise. Chuck Renner commented under a fake account, something Sarah figured out from a typo he'd made identically in an official HOA email weeks earlier. Long overdue, someone stood up to these squatters, the comment read. Squatters. Applied to a family with a recorded land grant from 1847. Told me exactly how detached from reality this had become. I finally posted a single comment myself, calmly stating our property predated the HOA by over a century and a half and citing the recorded grant number for anyone who wanted to verify it at the courthouse. The post got quiet fast. A few neighbors privately messaged Sarah, apologizing, admitting they hadn't known the history. Deb deleted the entire thread an hour later, replacing it with a bland reminder about upcoming pool maintenance. It was the first time I saw her retreat, even slightly, and it gave me a small, satisfying sense that facts still mattered to some people, even if Deb herself seemed determined to keep ignoring them. That satisfaction didn't last. 2 days later, a notice arrived announcing the HOA board had voted, unanimously and without any input from us, to restrict unauthorized vehicle traffic on the private road connecting our driveway to the county highway, a road we'd used for generations and that our deed explicitly guaranteed us access to. Nadia was furious when she read it. That road easement is recorded right alongside your original grant, she said. This isn't a gray area. This is her trying to physically cut you off from your own home. She fired back a letter threatening an immediate injunction of our own if the HOA installed any barrier. Deb backed off the road threat within a week, but only after Nadia's letter landed on Marcus Feld's desk. And even then she framed the retreat publicly as temporary community goodwill, as if she'd done us a favor rather than been legally cornered. I was starting to understand her pattern. Escalate, get pushed back, retreat, rebrand the retreat. By November, the fines in our drawer topped $4,000. Each one certified mail we now simply photographed and filed without opening the envelope fully. A small act of defiance that felt better than it probably should have. Sarah started calling the drawer Deb's diary, since it mostly just documented her escalating frustration with us. Deb, undeterred by legal pushback, shifted tactics toward isolation instead of confrontation. She quietly removed our names from the community directory, stopped forwarding us newsletters about shared amenities we'd never actually had access to anyway, and reportedly told newer residents we were in litigation with the association, which wasn't remotely true at that point. Ellen Rourke, our elderly neighbor, kept us updated on board gossip over coffee some mornings. She had Chuck bring up condemning your cabin at last week's meeting, Ellen said one Tuesday, stirring sugar into her mug like the news was casual. Somebody on the board actually asked if that was legal. She changed the subject fast. That detail, condemnation, stuck in my chest for days. Nadia explained that only the county, not an HOA, could pursue condemnation, and only through an extensive legal process involving public safety findings, which our cabin would never meet. Still, the fact that Deb was even floating the idea told me how far she was willing to go. Thanksgiving came and went quietly. A small mercy. Sarah's parents visited, and for a few days our cabin felt like ours again, filled with the smell of wood smoke and roasting turkey instead of certified mail. I almost let myself believe Deb had moved on to some other unfortunate target within her sprawling, restless empire of rules. That illusion shattered the first week of December, when a survey crew showed up unannounced at our property line. Hired, they said, by the Sable Ridge Lake Estates Homeowners Association to conduct a boundary verification survey. I called Pete Alvarez immediately, since he'd done our original survey work years earlier and knew our lines cold. That's not me, Pete said flatly. Somebody else got hired for this one. He sounded uneasy, which wasn't like him. I heard through the grapevine your HOA president's been shopping around for a surveyor willing to say your boundary sits differently than what's recorded. Most of us in the county told her no. Guess she found someone who'd say yes. The survey crew, working for a firm 2 counties over, spent an afternoon on our land before Nadia showed up with a cease order, citing our recorded grant and threatening trespass charges if they didn't leave immediately. They packed up fast, clearly unaware they'd been dropped into the middle of a much bigger fight than they'd been told. We later learned the surveyor, a young hire named Danny Osei who badly needed the work, had been offered an unusually generous fee to confirm an alternate boundary reading. Based on outdated 1970s tax maps Deb had somehow obtained, maps that predated modern GPS corrections and were riddled with known cartographic errors nobody used anymore. Danny, to his credit, quietly reached out to Pete a week later, guilt clearly eating at him. She wanted me to say the cabin sat on association land, Danny admitted. Offered to pay double if the numbers came out her way. Pete convinced him to put it in writing. Neither of us knew yet how important that document would become. Deb's obsession was no longer subtle. She'd moved from bureaucratic harassment to actively attempting to manufacture false property lines. A decision that, had it worked, could have genuinely stolen our land through sheer administrative confusion. I started sleeping poorly, replaying every interaction, wondering what she'd try next and how far her reach actually extended. Christmas brought a brief, strange truce. Deb sent no letters for 3 weeks, and I let myself hope, again, that she'd exhausted whatever this campaign was really about. Sarah remained skeptical. "Karens don't stop," she said, wrapping a gift for her sister. "They regroup." She was, infuriatingly, exactly right. In January, Chuck Renner started showing up at community events with a new title, Compliance Liaison, a role Deb had apparently invented and appointed him to without any board vote. His job, it seemed, was mostly to talk to homeowners about us, planting seeds that we were difficult, litigious, and hiding something about our property. One neighbor, a retired schoolteacher named Bill Okafor, confronted Chuck directly at the mailbox cluster. "Difficult how?" Bill asked. "They've got paperwork from 1847. Seems like you all are the ones hiding something, cooking up surveys and fake violations." Chuck mumbled something about board confidentiality and left without really answering the question. Bill told us about the exchange that evening, standing on our porch with his hands in his coat pockets. "Most of us knew your family before this association even existed," he said. "I don't know what Deb's angle is, but a lot of us aren't buying what she's selling anymore." It was the first real crack in her narrative. That crack widened slowly through February. A handful of longtime residents started pushing back at board meetings, asking pointed questions about the survey crew, the condemnation talk, the mounting fines against a property clearly outside the HOA's jurisdiction. Deb deflected each question with practiced ease, but I could tell, even secondhand, that her grip was loosening. Then came a twist none of us saw fully coming. Marcus Feld, Deb's own attorney, quietly reached out to Nadia asking to meet privately, off the record, at a coffee shop outside the county. Nadia went, wary but curious. What Marcus told her would reshape everything about how we understood Deb's real motivations. "She's not just doing this over aesthetics," Marcus admitted. According to Nadia's notes from the meeting, she wants your parcel folded into association common land. There's a clause about undeveloped shoreline access she's been trying to invoke. If your land got reclassified, it'd open up lake frontage the HOA's been fighting the county over for years. It wasn't personal pettiness alone. Or not only that. Deb had a financial and territorial motive buried under all the bureaucratic theater. A plan to absorb our historic parcel into the association's shared amenities, dramatically increasing lakefront access for the entire community. And, not coincidentally, her own property's resale value along with it. Marcus, turned out, had grown increasingly uncomfortable being asked to draft legal threats he privately believed had no merit. "I'm not going to lose my license over her ambitions," he told Nadia. Sliding across copies of internal memos Deb had sent him outlining her broader strategy in blunt, unmistakable language. It was damning. Nadia came home that night visibly energized, spreading the memos across our kitchen table. "This is intent," she said. This shows she knew your title was valid and pursued the fines and survey anyway, specifically to pressure you into settling or selling. That's not a misunderstanding. That could be actionable, maybe even fraud. Armed with Marcus's memos, Danny Osei's written admission about the bribed survey, and our full deed history, Nadia began quietly building a countersuit, one that would flip the entire dynamic if Deb ever actually followed through on her condemnation threats. For now, she advised patience. Let her keep making mistakes, Nadia said. She will. Deb didn't disappoint. She pushed the board to approve funding for outside legal counsel specializing in adverse possession claims, a move so legally backward that even sympathetic board members seemed confused. Adverse possession required continuous, hostile occupation of someone else's land, the opposite of everything true about our situation. She's grasping, Nadia said when I told her. Adverse possession would require you to be the trespasser, occupying land that's rightfully someone else's. You've got a recorded grant older than the state's current constitution. This isn't even a real strategy. It's desperation dressed up as legal language. Still, desperation, we were learning, could be dangerous. That desperation showed itself physically in April, when I found our driveway gate chained shut one morning, a padlock hanging where our own lock should have been. A laminated notice zip-tied to the chain cited unauthorized access to association-adjacent roadway pending boundary resolution. Sarah called the sheriff's department while I worked the chain off with bolt cutters. The deputy who responded, a patient older man named Sergeant Reyes, examined our deed on the spot and shook his head. This is your private easement, he said. Somebody committed criminal trespass and unlawful restraint of access here. You want to press charges. Nadia advised documenting everything first, building the case rather than escalating with charges immediately. Security footage from a trail camera Sarah had installed months earlier, mostly to catch deer, caught grainy but usable video of Chuck Renner's golf cart at our gate around 5 a.m., along with a shape matching Deb's Lexus parked further down the road. It wasn't conclusive on its own, but combined with everything else, it mattered. I confronted Chuck directly the next time I saw him, holding my phone up with the footage paused on his golf cart. He went pale, stammered something about just checking the fence line, and drove off without finishing the sentence. It was the first time I saw real fear cross his face instead of smug confidence. That fear, turned out, was the beginning of something useful. A week later, Chuck sent Nadia an anonymous email from a burner account, though the writing style matched his Facebook comments almost exactly. I have information about board activity you should know about, it read. I need protection before I say more. Nadia agreed to meet. Chuck, sitting nervously across from Nadia at a diner outside the county, admitted the padlock had been Deb's idea. Along with several earlier compliance patrols he'd conducted specifically at her direction, targeting only our property. She told me it was authorized, he said. I didn't ask enough questions. I just wanted to be useful to her. For a stretch of weeks after that, things went eerily quiet again. No fines, no letters, no surveyors. Sarah and I almost let ourselves relax, tending the garden, fixing the porch railing, taking the dog down to the water without checking over our shoulders every few minutes. Felt, briefly, like our old life again. Nadia warned us not to mistake silence for surrender. People like Deb don't fold, she said. They regroup somewhere quieter. She kept building the case methodically, filing the memos, Danny's statement, and the trail camera footage into a growing folder, while quietly reaching out to the county clerk's office to confirm every detail of our grant's recording history. Ellen Rourke reported that Deb had been unusually absent from casual community life during this stretch, skipping the spring mixer she normally hosted personally. Word is she's meeting with people outside the county, Ellen said. Real estate lawyers. Maybe. Something about the assessor's office too. Nobody quite knows what she's cooking up this time. What Deb was actually doing, we'd later piece together, was pursuing a much more aggressive legal route, hiring a firm specializing in eminent domain and tax lien acquisitions, hoping to find some administrative loophole that could force a sale or transfer without needing the HOA's covenants to apply at all. She'd also, we discovered far later, quietly begun exploring whether our property taxes had ever lapsed at any point across a century and a half, hunting for any technical default that might let her purchase a tax lien certificate and eventually force foreclosure. A long shot, but one she seemed increasingly desperate enough to pursue. Sarah's mother, visiting for a week in May, remarked one evening how strange it was that a woman none of us had wronged had apparently reorganized her entire life around taking something that was never hers to take. Some people build identities around winning, Sarah's mother said. Doesn't matter what they're winning, or who gets hurt. That observation stuck with me more than I expected. It wasn't really about the cabin, or the lake access, or even the money anymore. Not entirely. It was about a woman who'd built her sense of self around control, and who couldn't tolerate one small, stubborn piece of the map that refused to bend to her will. In late May, Pete Alvarez called with news that shifted things again. I ran into Danny Osei at a supply store, Pete said. He told me Deb's been calling him, pressuring him to recant his statement, offering money this time instead of threats. He's scared to talk to him again. Soon. Nadia met with Danny that week, formalizing his earlier admission into a sworn affidavit, protecting it against any future pressure to recant. Danny signed without hesitation, visibly relieved to have it documented properly. I just want this over, he told her. I've got a kid on the way. The quiet spell finally broke in early June, when a certified letter arrived announcing the HOA board had voted to pursue formal eviction proceedings against our property, citing unresolved boundary disputes and repeated covenant violations. Sarah read it twice before setting it down carefully, like it might detonate if handled roughly. Nadia, when I called her, sounded almost pleased, which surprised me until she explained. This is what we've been waiting for, she said. She's finally putting her theory in front of a judge. Every piece of evidence we've gathered, Marcus's memos, Danny's affidavit, the trail camera, all of it becomes admissible now. She's walking into this blind. Still, the word eviction landed heavy in our chest despite Nadia's confidence. It meant a court date, a real one, with real stakes attached, the kind that could theoretically upend our entire life if something went wrong in ways none of us anticipated. Sarah started having trouble sleeping again, and honestly, so did I. We spent a weekend going through the old cedar chest more thoroughly than I ever had before, cataloging every document inside. Deeds, letters, a hand-drawn 1847 survey sketch, and beneath a false bottom I hadn't even known existed, a folder Ruth had labeled simply, "If anyone ever tries." My hands shook opening it. Inside were photocopies of the original land grant, notarized decades earlier, alongside a letter from Ruth herself, dated the year before she died, explaining that a previous development company had tried something similar in the 1990s, and detailing exactly which archives held the strongest supporting records if anyone ever needed to prove our claim again. Ruth's letter read, in part, that she'd worked with the County Historical Society to have our original grant cross-referenced and preserved after that earlier scare, specifically anticipating exactly this kind of fight decades before Deb Winslow ever moved to the lake. My grandmother, turned out, had been protecting us from beyond the grave. Nadia was floored when I brought the folder to her office. "This isn't just supporting evidence," she said. Flipping through certified historical society records Ruth had arranged to be duplicated and stored off-site. "This is a fortress. Whoever's advising Deb clearly has no idea what's actually sitting in your family's paperwork right now." Buoyed by the discovery, we shifted from playing defense to actively preparing offense. Nadia filed a formal response to the eviction petition, not just denying the HOA's claims but outlining, in detail, the fraudulent survey attempt, the improperly restricted easement, and the fabricated code complaints, laying groundwork for a counterclaim she planned to file separately. Deb, unaware how thoroughly the ground had shifted beneath her, doubled down publicly. At the July board meeting, she announced the eviction hearing date to the entire community, framing it as a long overdue correction. "We've given this family every opportunity to comply," she told the room, "and instead they've chosen litigation over cooperation." Ellen Rourke, sitting near the back, later told us several longtime residents visibly bristled at that framing. "Compliance with what?" one woman reportedly called out. "They're not even in the HOA." Deb brushed the comment aside, insisting legal counsel would clarify everything at the hearing, though Marcus Feld, sitting beside her, looked distinctly uncomfortable. That discomfort, we'd learn, had a specific cause. Marcus had quietly begun drafting a motion to withdraw as Deb's counsel, unwilling to continue representing claims he now believed, based on what he'd reviewed, had no legal foundation and possibly exposed him to sanctions if he pushed forward with the eviction petition as written. In August, Chuck Renner resigned his compliance liaison role abruptly, citing personal reasons in a 2-line email to the board. Privately, he told Nadia he'd grown terrified of being pulled deeper into something he now recognized as potentially criminal, especially after learning Danny's affidavit existed and detailed the bribery attempt explicitly. Deb, undeterred by Chuck's quiet exit, recruited a newer board member, an eager young transplant named Priya Malhotra, to take over enforcement duties. Priya, unlike Chuck, actually read the bylaws carefully, and within weeks began privately questioning aspects of the eviction case that didn't add up, though she kept those doubts largely to herself for now. Meanwhile, Deb's personal life started cracking under the pressure of her own obsession. Her adult daughter, visiting from out of state, reportedly told a mutual acquaintance that her mother had become unrecognizable over the past year, consumed entirely by the fight with us, missing family events to attend emergency board sessions about our fence line. We heard, secondhand through Ellen, that Deb's second husband had moved out that summer, unable to tolerate what he called her obsession with the Callahan property. Whether true or exaggerated in the retelling, it fit a pattern we'd watched unfold for over a year, a woman increasingly isolated by her own need to win. September brought the discovery that would eventually crack the case wide open. Priya Malhotra, digging through old board records to prepare enforcement documentation, stumbled across inconsistencies in the vote tally from Deb's original presidential election 3 years earlier, numbers that simply didn't match the sign-in sheets from that meeting. Priya mentioned it casually to Ellen, not realizing its significance, and Ellen, sharper than anyone gave her credit for, immediately connected the dots and called us that same evening. "Something's off with how Deb got elected in the first place," Ellen said.
"You might want your lawyer to look."
Nadia filed a records request with the county the next morning, pulling 3 years of HOA governance filings, since Sable Ridge, like many associations, was required to submit annual compliance paperwork to maintain its nonprofit status. What she found, cross-referenced against Priya's sign-in sheets, suggested the numbers had been altered after the fact. 14 votes were added to her total that don't correspond to any signed ballot, Nadia told me, spreading photocopies across her desk. If this holds up, Deb's presidency itself might be invalid, which would call into question every action she's taken under that authority, including everything against your property specifically. It was a stunning thread to pull, one that had nothing directly to do with our land dispute and everything to do with who actually had legal standing to pursue it in the first place. If Deb's presidency was fraudulent, her entire campaign against us might collapse on a technicality nobody had anticipated a year earlier. We didn't tip our hand, being the election discovery quiet, filing it as a sealed exhibit rather than announcing it publicly, preserving the element of surprise for the actual hearing rather than giving Deb time to fabricate an explanation or destroy any remaining evidence before we could formally present it in court. October brought one final attempt at intimidation before the hearing. A moving truck appeared unannounced at our property line one morning, driver confused, insisting he'd been hired by the Winslow residents to begin relocating structures per court order, despite no such order existing. Sarah recorded the entire confused exchange on her phone. The driver, once he realized something was deeply wrong, apologized and left without touching anything, but not before showing Sarah the work order on his tablet, which listed Deb's name and address as the client, along with a description of our cabin and an authorization number that, Nadia confirmed later, had simply been invented. She's trying to manufacture the appearance of legal authority before she actually has any, Nadia said, adding the incident to our growing file. This is either supreme confidence that she'll win, or complete disregard for what's actually true. At this point, I genuinely think it might be both. I was inclined to agree. With the hearing 3 weeks out, Nadia and I spent long evenings preparing exhibits. The original 1847 grant and its 1921 and 1968 updates, Ruth's Historical Society records, Danny's sworn affidavit, Marcus's internal memos, the trail camera footage, and now, carefully sealed, the election tally discrepancies Priya had unknowingly uncovered. Marcus Feld formally withdrew as Deb's counsel that same week, filing a brief, professionally worded motion citing irreconcilable differences regarding case strategy. Deb, scrambling, hired a replacement attorney from out of county on short notice, a man named Roy Petrakis who, it would soon become clear, had barely reviewed the underlying documents before agreeing to take the case. Roy's first move was requesting a continuance, which the judge, a no-nonsense woman named Marion Wexler, known throughout the county for her impatience with frivolous motions, denied outright. This hearing was scheduled months ago at the association's own request, Judge Wexler noted dryly.
I don't see grounds for delay, just...
Deb, according to Priya, grew increasingly erratic in the final weeks before the hearing, calling emergency board sessions late at night, demanding loyalty pledges from members, and reportedly threatening to sue anyone who undermined the association's position in the press or on social media. Several board members, Priya included, quietly began distancing themselves. Ellen Rourke told us Deb had started referring to the case in almost personal, mythic terms at these late meetings, calling it a fight for the soul of this community rather than what it actually was, a woman trying to seize land she had no legal claim to through pressure,
fabrication,
and sheer force of will. The night before the hearing, Sarah and I sat on our porch with the dog between us, looking out at the lake Ruth's great-grandfather had chosen a century and a half earlier. Whatever happens tomorrow, Sarah said, we know the truth. That has to count for something. I hoped, fiercely, that she was right about that. Nadia called that evening with final instructions, calm and methodical as always. Let the documents speak, she said. Deb built this entire case on assumption and intimidation. We're going to answer with paper. Judges respect paper. Especially paper that's 179 years old and still holds up perfectly under scrutiny. We arrived at the county courthouse the next morning to find the parking lot fuller than expected. Several familiar faces from the estates among the crowd. Bill Okafor, Ellen Rourke, even Priya Malhotra, sitting quietly in the gallery. There, we'd later learn, specifically to watch how this played out for themselves. Deb arrived 20 minutes later with Roy Petrakis at her side, wearing a sharp navy suit, her HOA lanyard conspicuously absent for once. She looked composed, almost triumphant, clearly still believing this hearing was a formality on her way to finally, permanently, removing the Callahan cabin from her carefully curated lakeside kingdom. Judge Wexler entered the courtroom precisely on time, reviewing her notes briefly before addressing both parties. This is a petition for eviction and boundary determination brought by the Sable Ridge Lake Estates Homeowners Association against Wade and Sarah Callahan, she said. Counsel for the petitioner, you may begin with your opening statement. Roy Petrakis stood, visibly underprepared, and launched into an opening argument built almost entirely around community standards and covenant compliance, language that made Nadia visibly relax beside me. He hadn't grasped, or hadn't been told, that our property's threshold legal status made most of the association's covenants irrelevant from the very first sentence. The Callahan property, Roy said, has repeatedly and knowingly violated the recorded covenants of the Sable Ridge Lake Estates community, including unauthorized structures, boundary encroachment, and failure to comply with mandated aesthetic standards. Judge Wexler interrupted him almost immediately. "Counsel, has jurisdiction actually been established here? I don't see it addressed in your filing." Roy stumbled, glancing back at Deb, who mouthed something urgently from her seat. "The association considers the property within its purview based on shoreline proximity," he offered weakly. Judge Wexler's expression didn't change, but something in her posture told everyone in the room she found that answer distinctly unsatisfying. Nadia rose for our opening statement, calm and unhurried. "Your Honor, the Callahan family's property was granted under an 1847 state land patent, recorded decades before the Sable Ridge Lake Estate subdivision existed in any form. It has never been, and cannot legally be, subject to covenants established more than a century and a half later." She placed the original grant, alongside its 1921 and 1968 recorded updates, into evidence, along with the Historical Society's supplementary documentation Ruth had arranged years earlier. Judge Wexler examined the pages slowly, her earlier impatience shifting into something closer to genuine, focused interest as she turned each carefully preserved document over in her hands. "This is remarkably well documented for a property this old," Judge Wexler noted, almost to herself. "Counsel for the petitioner, were you aware of this grant history prior to filing this eviction petition?" Roy hesitated, glancing again at Deb, who was staring straight ahead now, her earlier composure noticeably beginning to fracture at the edges. "We were aware there were," Roy admitted carefully. "Our position was that formal exemption required board approval through the association's appeals process." Judge Wexler set the documents down.
"An association cannot require a landowner to seek exemption from covenants that were never—"
The courtroom stayed quiet, but I could see Bill Okafor in the gallery shaking his head slowly, and Ellen Rourke's small, satisfied smile. Deb, for the first time in over a year, looked genuinely uncertain, her carefully constructed narrative visibly buckling under the simple, undeniable weight of paperwork older than her entire subdivision combined. Roy, scrambling, pivoted toward the boundary dispute angle instead, introducing the disputed survey from the outside firm, insisting it showed our cabin encroaching onto association common land. Nadia was ready. "We'd like to introduce a sworn affidavit regarding the circumstances under which that survey was conducted," she said. Danny Osei's affidavit, detailing the attempted bribe and the outdated, error-riddled 1970s maps used to justify the alternate boundary reading, landed in the courtroom like a dropped stone. Judge Wexler read it in silence, then looked directly at Deb for the first time since the hearing began, her expression noticeably cooling. "Mrs. Judge Wexler said, were you involved in soliciting this alternate survey?" Deb's new attorney tried to object, but Judge Wexler waved him off. "This is a civil hearing, counsel, and this document is directly relevant to the credibility of the petitioner's boundary claims. I'd like an answer." Deb, after a long pause, said only that she'd explored various options to clarify the boundary, a carefully lawyered non-denial that satisfied nobody in the room, least of all Judge Wexler, who made a note on her legal pad and moved forward without further comment, though her posture had visibly stiffened. Nadia then introduced the trail camera footage, along with Sergeant Reyes's incident report from the padlocked gate, and Chuck Renner's written statement, provided quietly weeks earlier and now formally entered as evidence, describing Deb's direct instructions to restrict the Callahans' recorded easement access without any board authorization whatsoever. Your Honor, Nadia continued, this pattern, fabricated code complaints that inspectors found baseless, a bribed survey attempt, unauthorized restriction of a recorded easement, demonstrates the petitioner pursued this eviction not on legitimate legal grounds, but through a sustained campaign of harassment against a family whose title was never in genuine question. Roy tried one final pivot, arguing that even setting aside the survey and access issues, the board's authority to pursue the eviction petition itself remained valid regardless of any individual misconduct. It was, ironically, the opening Nadia had been patiently waiting for through the entire hearing, and she didn't let it pass by. Your Honor, we'd like to address the board's authority directly, Nadia said, specifically the validity of the current HOA presidency under which this petition was authorized. Judge Wexler raised an eyebrow, clearly not expecting this turn. Please proceed. Counsel, she said, setting down her pen entirely now. Nadia introduced the sealed exhibit, the discrepancy between recorded sign-in sheets and the certified election tally from Deb's original presidential election, alongside county nonprofit filings showing the altered numbers had been submitted under Deb's signature. The courtroom went utterly silent, the kind of silence that has actual physical weight to it. 14 votes appear on the certified filing that have no corresponding signature on the meeting's official attendance record, Nadia explained. If the election itself is invalid, then Mrs. Winslow's authority to direct board action, including authorizing this eviction petition, is called directly into question. Deb's face had gone completely white. Judge Wexler examined the documents for what felt like an eternity, though it was probably closer to 2 full minutes. When she finally looked up, her expression carried something between disbelief and barely restrained frustration. Mrs., she said slowly, would you like to explain this discrepancy to the court? Deb's new attorney, Roy, looked like a man realizing far too late exactly what case he'd agreed to take. He leaned toward Deb, whispering urgently, but she pulled away from him, standing abruptly instead. Your Honor, I'd like a moment with my counsel, she said, her voice noticeably tighter than it had been an hour earlier. Judge Wexler granted a brief recess, and the courtroom buzzed the moment Deb and Roy stepped into the hallway. Ellen leaned over to us, whispering, I haven't seen her look like that in 3 years. Even Priya Malhotra, sitting a few rows back, looked visibly stunned by the scale of what was unraveling in real time. When court resumed 20 minutes later, Roy formally withdrew the eviction petition's boundary and compliance claims, though he tried to preserve the underlying association authority question, clearly hoping to salvage something from the wreckage. Judge Wexler, however, wasn't finished, and made clear she had significantly more to address before adjourning. Before we conclude, Judge Wexler said, I want to be extremely clear on the record. This court finds the Callahan property's title, recorded under an 1847 state land patent, and consistently maintained through subsequent recorded updates, entirely superior to and predating any authority claimed by the Sable Ridge Lake Estates Homeowners Association. Furthermore, she continued, the evidence presented today, the fabricated code complaints, the improperly solicited boundary survey, the unauthorized restriction of a legally recorded easement, and now serious questions regarding the validity of the petitioner's own governing authority, suggests conduct that may warrant referral beyond this civil matter entirely. Deb, still standing, seemed to physically shrink under the weight of that sentence. Your Honor, I was simply trying to maintain community standards, she said, her voice cracking slightly. Judge Wexler's response was measured but unmistakably firm. Community standards do not include falsifying survey results or manipulating election tallies. Mrs. Winslow, the judge dismissed the eviction petition entirely, with prejudice, meaning the HOA could never refile the same claims again. She further issued an order permanently barring the association from asserting any jurisdiction over our property, and from interfering with our recorded easement access in any capacity going forward, effective immediately. Then, almost as an afterthought that landed with tremendous weight, Judge Wexler addressed Nadia directly. Counsel, given what's been presented regarding the election irregularities, I'd recommend your clients consider filing a formal complaint with the state's nonprofit oversight board, and possibly a referral to the district attorney's office as well. Sarah gripped my hand so tightly it hurt, though I barely noticed at the time, still processing the fact that after 14 months, it was actually, finally, unambiguously over. Deb sat back down slowly, staring at the table in front of her, the laminated confidence that had defined her for years completely, visibly gone. Outside the courthouse afterward, reporters from the local paper, tipped off by someone in the gallery, caught up with us on the steps. I kept my comments brief, thanking our attorney and simply stating that the truth and the paperwork had spoken for themselves. Sarah, beside me, finally allowed herself to cry, relief flooding out all at once. Bill Okafor and Ellen Rourke found us in the parking lot, both grinning in a way I hadn't seen from either of them in over a year. I've got to say, Bill said, watching that judge's face when she read that election report was the best thing I've seen at that courthouse in a decade. Priya Malhotra approached more hesitantly, apologizing for not connecting the dots sooner about the election discrepancy. I had no idea what I was actually looking at when I found it, she admitted. I'm just glad it mattered. I told her it had mattered more than she probably realized, and thanked her sincerely. Within days, news of the hearing spread through the estates faster than any newsletter Deb had ever sent. The community Facebook group, once a platform for her narrative, filled instead with residents demanding an emergency board meeting to address both the eviction fiasco and the newly surfaced election fraud allegations against her leadership. That emergency meeting, held the following week, was packed beyond capacity. Homeowners standing along the walls of the clubhouse Deb had once championed. Chuck Renner, notably, did not attend, having already quietly resigned his remaining board affiliations entirely. Deb sat at the head table, visibly diminished, flanked by an increasingly distant Roy Petrakis. The board voted, 7-1, to remove Deb from the presidency immediately, citing both the court's findings and the election irregularities uncovered during the hearing. The single dissenting vote came from a longtime ally who abstained from further comment. Priya Malhotra was nominated on the spot as interim president, and accepted, somewhat reluctantly, in the weeks that followed. the state's nonprofit oversight board opened a formal inquiry into the association's governance under Deb's leadership, examining not just the disputed election but years of financial records. Since rumors had begun circulating that certain compliance fine revenues had never actually made it into the HOA's official accounts, that inquiry turned out uncovered something even Nadia hadn't anticipated. Nearly $31,000 in fines collected from various homeowners over 3 years, including a portion of what we technically never paid, but that had somehow still been logged as collected in Deb's personal financial summaries submitted to the board. Priya, working with the Oversight Board's auditor, discovered the discrepancy traced back to a separate account Deb had opened under a slightly altered version of the HOA's name, Sable Ridge Lake Estates Association. Instead of association, subtle enough to avoid casual notice, but different enough to redirect deposits made by unsuspecting title companies and vendors. The district attorney's office, following the judge's referral, opened a formal investigation into both the election fraud and the financial irregularities, treating them as related components of a broader pattern of misconduct rather than isolated incidents. Deb, through a new criminal defense attorney, declined to comment publicly on any of it. Marcus Feld, despite having withdrawn from the eviction case, found himself called as a witness in the broader investigation, given his earlier role as Deb's counsel. He cooperated fully, providing his internal memos voluntarily, memos that further corroborated the financial motive behind the entire campaign against our property from the very beginning. Danny Osei, relieved beyond words that his affidavit had helped end things, told Pete Alvarez he'd been offered his old survey firm's blessing to take on more work in the county now that the truth was out. Funny how honesty works out sometimes, Pete told me, relaying the story with visible satisfaction. Chuck Renner, for his part, avoided criminal charges by cooperating fully and early with investigators, though he moved out of the estates entirely within 2 months. Unable, according to Ellen, to face the neighbors he'd spent over a year quietly harassing on Deb's behalf without fully understanding, or wanting to understand, what he was part of. The community itself began healing in small, visible ways. The clubhouse hosted a genuinely well-attended potluck that spring, the first in years without an undercurrent of tension. Bill Okafor brought his famous barbecue. Ellen brought 3 different pies. Sarah and I brought firewood-smoked cornbread. And for once, nobody photographed our contribution as a violation. Priya, settling into her role as interim president, reached out to us personally, asking if we'd be willing to have our cabin formally recognized as a point of local historical interest, a gesture that felt less like bureaucracy this time and more like genuine, overdue respect for what our family had preserved. We agreed, and that summer, working with the County Historical Society Ruth had partnered with decades earlier, our cabin received an official historical marker, a small bronze plaque noting the 1847 land grant and the family that had maintained the property continuously ever since. Ruth would have loved the ceremony, quiet and understated, exactly her style. Deb, meanwhile, faced her own reckoning slowly through the summer and fall. The state nonprofit board formally invalidated her original election, and every board action taken under her presidency that hadn't already been independently ratified, throwing years of HOA decisions into a temporary but eventually resolved legal limbo the new board worked carefully to untangle. The district attorney's office, after months of investigation, ultimately charged Deb with 2 counts of embezzlement related to the misdirected fine payments, along with a single count of election fraud tied to the falsified vote tally. She pleaded no contest to reduced charges the following spring, avoiding trial but accepting real consequences. Her sentence included restitution to the association totaling the full misappropriated amount, 3 years of probation, and a formal order barring her from holding any position of authority within a homeowners association or similar governing body anywhere in the state for the following decade, a fittingly specific and permanent consequence. She sold her lakefront house within the year, moving away from Sable Ridge entirely, according to Ellen, to a small town 2 counties over where, presumably, nobody yet knew the story. Chuck Renner's whereabouts became less certain over time, though rumors placed him working retail somewhere well outside the region, far from any golf cart. Roy Petrakis, Deb's last-minute attorney, faced no formal sanctions himself, though the County Bar Association reportedly issued him a private advisory regarding due diligence obligations before accepting contentious property disputes, a quiet professional consequence for having walked into a courtroom battle he'd never adequately understood before agreeing to fight it. Marcus Feld, by contrast, emerged from the entire ordeal with his reputation genuinely enhanced, known now around the county courthouse as the attorney who'd done the right thing even at professional cost to himself. He sent us a brief, gracious note that autumn, wishing us well and expressing quiet relief the truth had finally surfaced. As for us, life on the ridge slowly returned to something resembling its old rhythm, though changed in small, lasting ways. Sarah still keeps a folder of important documents, a habit born from necessity that never quite faded, and I check our deed history every few years now, just to be sure, though I no longer expect trouble. The following spring, standing on our porch watching the lake catch the early morning light exactly the way it had for 179 years before any of this began, Sarah turned to me and said, "Your grandmother knew something about people like Deb, didn't she?" I told her I thought Ruth probably had. We never did find out precisely what happened during that earlier 1990s scare Ruth's hidden letter referenced, the one that had prompted her to preserve our documents so meticulously decades before Deb Winslow ever set foot on the lake. Some family history, I've come to accept, stays partially a mystery, protected but unexplained. What I do know is this: my great-great-grandfather claimed this ridge in 1847, decades before any lake, any subdivision, any laminated badge existed to challenge him. My grandmother quietly guarded that claim for the rest of her life, anticipating a fight she'd never lived to see, and leaving us everything we needed to win it anyway. And when a woman who'd never once bothered to check the actual history of the land beneath her own manufactured authority finally stood in a courtroom and tried to
erase 179 years of recorded truth, a judge opened one folder, read one page, and simply, unmistakably, laughed at the absurdity of it all.
That laugh, more than the ruling itself, more than the fines dismissed or the eviction thrown out, became the moment I return to whenever I think about that year. Not triumphant, not cruel, just genuinely, honestly amused at how completely, spectacularly Deb had misjudged the fight she'd chosen to pick with a family that never backed down. The estates elected a new board the following January, one that quietly rewrote its enforcement bylaws to require clear jurisdictional review before pursuing any compliance action. A direct, unspoken response to everything that had happened. Priya, still interim president at the time, joked it should be called the Callahan Clause. The name stuck. Sarah and I still get invited to community events now. Genuine invitations rather than obligatory tolerance. And though we mostly keep to ourselves the way we always have, we go sometimes, bringing cornbread, sitting with Ellen and Bill, watching a neighborhood slowly rebuild the trust one obsessive, controlling woman had spent years quietly eroding. Occasionally, new residents ask about the bronze plaque near our driveway, curious about the history behind it. I tell them the short version. Land grant, 1847, 3 generations before the lake even existed. Most nod politely. A few, the ones who've heard the fuller story, just smile and say, "Oh, that Karen." I've thought a lot, since then, about what actually protected us through all of it. Not luck, exactly, though we had some. Not confidence alone, since I spent plenty of nights doubting everything. What protected us was paper, careful and patient, gathered by people, Ruth most of all, who understood that truth needs documentation to survive a fight. Deb, wherever she is now, built her entire campaign on assumption, on the belief that confidence and a laminated badge could substitute for actual legal standing. She learned, expensively and publicly, that 179 years of recorded history doesn't bend just because someone insists loudly enough that it should. The cabin still stands exactly where Ezra Callahan built it. Tin roof singing in the rain. View of the lake unchanged by any of it. Sarah and I still split our own firewood. Still keep chickens. Still mostly keep to ourselves. Except now, when someone asks about our home's history, we tell the whole story, twist and all, because in the end, that's what this really was. Not a fight over paint colors or property lines, but a fight over whether one woman's need for control could override a century and a half of documented, undeniable truth. Couldn't. Chance. Not once the right folder finally opened in the right room. Ruth used to say the land would outlast anyone who tried to take it. And she was right in ways I don't think even she fully anticipated. It outlasted Deb's ambition, outlasted the fines and the fabricated surveys, outlasted a woman who mistook a laminated badge for actual authority over land she never had any claim to. These days, the estates feels different, lighter somehow, the way a room feels after a long, oppressive weather system finally breaks. Priya's board runs things with genuine transparency now, and the clubhouse hosts potlucks instead of compliance meetings. Nobody photographs our woodpile anymore. Nobody chains our gate. The lake, finally, just gets to be a lake. Nadia still checks in occasionally, mostly just to say hello. Though she jokes that our case remains her favorite story to tell new associates. The one with the judge who laughed. I tell her we're grateful, genuinely, for every hour she spent building something so solid Deb never had a real chance against it. Pete Alvarez still surveys land around the lake. And Danny Osei, we heard, eventually started his own small firm 2 counties over, built partly on the reputation of having done the right thing when it mattered most, even at real personal risk. Some things, turns out, really do work out the way they should. If there's a lesson in all of this, and I've had plenty of quiet evenings on that porch to think about it, It's that authority without truth is just theater. However convincing the props. Deb had the badge, the binder, the board votes, the confidence. What she never had, not for a single day, was the law. We're still here. The lake still catches the morning light exactly the way it did in 1847. Exactly the way it will, I imagine, long after all of us, Callahans and Karens alike, are nothing more than a footnote in some future family's cedar chest, waiting patiently to be opened. Some nights, sitting on the porch with Sarah and the dog, I still think about that courtroom moment, Judge Wexler's genuine, unguarded laugh echoing off the walls as she read Ruth's carefully preserved documents. It wasn't mockery. The simple, satisfying recognition of a truth too solid to argue with. And honestly, that's enough for me. Not revenge. Not spectacle. Just the quiet, permanent satisfaction of watching truth finally outlast pretense. In a courtroom, on paper, in the exact place it always belonged. Ruth knew that would happen eventually. I just wish she'd been there to see the judge's face herself. The plaque by our driveway catches afternoon light now. Bronze against old wood. And every time I walk past it I think about how close we came to losing. Something 4 generations had protected. Simply because one woman decided her authority mattered more than a century and a half of recorded, undeniable fact. Didn't. Not really. Not when the paperwork's solid and the people holding it refuse to fold. Ruth Callahan made sure of that decades before any of us knew we'd need it. And somewhere, I like to think, she's the one laughing loudest of all, right alongside that judge. The END.